Okay, so thank you again
Yes.
for the introduction.
I need some for a long time. Okay.
Okay,
Okay.
go ahead and mute this
You
participant.
can mute. Yeah. Varish.
Yeah.
Yeah.
Okay, well, good morning, everyone. Thank you so much for joining us on our webinar for Green Card Pathways for Postdocs and graduate students. As Abdul mentioned, we are the Immigration Law Offices of Hadley Baramovich, and my name is Varisha Pereira, and I'm the Employment-Based Visas Manager here at the firm. So we specialize in green cards and visas for postdocs and graduate students, like the EB-1A, the EB-1B, and the EB-2 NIW. We're located in Riverside, California, very, very close to the University of California, Riverside, which is one of the top research institutions, and that's where our work with postdocs began, because our lead attorney and the founder of the firm as well, Hadley Baramovich, is very well acquainted with postdocs, as she started her career there as well at the University of California, Riverside as the Director of International Scholars. So we will go ahead and start the presentation for today. Give me 1 second. Okay. So in today's presentation, we want to go over some of the most common employment-based green card categories and visas that are available for international postdocs and graduate students. We will talk about the two-step process, which is the I-140 and then the I-485 process. Then we'll switch over to talk about priority dates and the visa bulletin, which is often a very complex concept. So we want to make sure that we break it down in the most simple terms for you. We'll talk about strategies to build your profile and the kinds of evidence that you can start to collect to build your green card application. We'll also talk about the J-1 Waiver Process, as a lot of postdocs are sometimes subject to the 212E obligation. So Attorney Hadley will cover the J-1 Waiver Process as well, and then we'll have plenty of time for your questions and for us to be able to respond to some of those. Though at any time during the presentation, if you would like to ask a question, feel free to use the chat. We'll be monitoring the chat as well so that we can get to your questions. Okay. So the main categories, as I mentioned before, that we specialize in and that most international postdocs will definitely qualify for are the EB-1A, the EB-1B, and the EB-2 NIW. So we will start with the EB-1A, which is the Extraordinary Ability Green Card, and this is the highest standard for green cards, meaning that we have the highest burden of proof with this green card. So it's sometimes referred to as the Einstein Green Card, meaning that if you've ever won, a Nobel Prize or any other prize of that level, then you automatically qualify for this green card. If you do not, or if you have not received a Nobel Prize at this time, that's okay. You definitely still can qualify for the EB-1A. We just have to demonstrate that you do meet the level of extraordinary ability and that you've risen to the top of your field by showing that you meet at least 3 criteria. So firstly, to mention, the EB-1A does not require a job offer or permanent position, so it's completely self-petitioned, just like the EB-2 and IW, and you can start this process at any time. Like I mentioned, we do have to prove that you've risen to the top of your field and that you're one of the very few who've risen to the top of your field of endeavor. And then we do have to show that you have sustained national and international acclaim in your field, that you will continue to work in your field in the US, and that you and your work will benefit the United States. So we show all of this and we build your case for the EB-1A by demonstrating that you meet at least 3 of the following criteria. And we'll go through this criteria a little bit slower as well, so that you can have a better understanding of the kinds of evidence that you can start to prepare or look out for on your CV as well to build your profile for the EB-1A. Okay, so starting with receipt of lesser nationally or internationally recognized prizes or awards for excellence in your field. If you have ever received an award, for your research, for posters sometimes as well, or for any other work in your field, this would qualify you to meet this criteria. At the EB-1A level, we definitely have to provide a lot of evidence, such as the certificates for your awards, award letters. We have to demonstrate the scope of the award, the criteria for the award, and other aspects of the award, such as how many people were eligible for that, award, or out of how many, or the applicant pool in general. So we do have to submit quite a bit of evidence to establish that this is a nationally or internationally recognized prize or award for excellence in your field. The next one is membership in an association that requires outstanding achievements of their members as judged by recognized national or international experts. So this is typically a tougher criteria to meet for the EB1A, just because we do need to show that you were invited to join a professional association based on excellence in your field of endeavor. And what that means really when we are trying to, provide evidence for this criteria, we have to show with the bylaws or other documentation from the professional association that you were invited to join based on excellence in your field of endeavor, and that your membership of that association is really a result of your outstanding performance in your field. This can be a little bit of a trickier criteria to meet, just because for the EB1A level, we do have to show that high level of outstanding performance, whereas as we'll see later for the EB2 and IW, the burden of proof for this criteria is much lower. The next criteria is published material about you and your work in professional trade journals or major media. So if you and your work have ever been featured in major media online or in print, then you would qualify for this criteria. We would have to, do research into the trade journals or major media where you and your work have been published, and we'd have to provide, evidence on the circulation to establish it as a major trade journal or major media in your field. So this could be, articles, interviews, or any other features that discuss your work and your contributions to the field. Something that USCIS has been really cracking down on for this criteria is to ensure that all of these published material have a clearly listed title, date, and author for the publication, or else they, sometimes give us a tough time through an RFE. Okay. The next criteria is your participation as a judge of the work of others, either individually or on a panel. So if you've ever judged the work of others in your field, if you've completed peer review, if you've been invited to review journal articles or served on conference panels, judged competitions, judged grant applications, or evaluated work of others in your field, then you would qualify for this criteria. So the kinds of evidence that we submit are often, either email confirmation saying thank you for completing the peer review for so-and-so journal article. Sometimes you might receive a certificate. Sometimes you might even have a position as an editor or a reviewer for a journal. So we would submit evidence of all of that for this criteria. The next one is evidence of original contributions of major significance in your field. So original contributions, I'm sorry, are you all able to see my screen?
You could able to say it, yeah.
Okay, are we on the slide EB1A extraordinary ability?
Yes.
Okay. Yes, so we're still on the same slide. Okay, I got a chat message saying slide is not changing. I haven't changed the slide yet. We're almost towards the end. Yeah. Okay, so for evidence of original contributions of major significance of your field, this is perhaps the most important criteria for the EB1A. We do have to show that your work, your original work, has impacted the field in a major way. And we do this through, letters of recommendation, through your citation record, through any patents that you might have worked on that's been issued and granted. So this is typically a very, very important criteria for the EB1A, and we really look at drafting strong objective letters of recommendation that we get from experts in your field to basically attest to the importance of your work and the significance that it has had in the field. Okay. Moving on to the next criteria. So authorship of scholarly articles in the field. This is a fairly easy one to meet. If you've ever published in professional journals or other major media, you would automatically qualify for that criteria. And then the rest of these criteria typically not so easily applicable to postdoc profiles, but I'll go over them briefly. So it's evidence that your work has been displayed at artistic exhibitions or showcases, performance in a significant role for organizations or establishments with a distinguished reputation. So for performance in a significant role, this one actually might, be applicable to some of you. So if you've ever worked in the industry or served in a role that was critical to the organization or leading in nature, then we would be able to qualify you for this criteria. And the kinds of evidence that we would need to submit to show that you performed in a critical or leading role would just be letters from your employers and your supervisors, or any other documentation that describes your roles and responsibilities for that organization. And we have to spend a lot of time detailing how they were critical or leading in nature. Receipt of a salary or remuneration higher than is usual in the field. So if you are earning, or if you have earned a salary that has been higher than others in relation to others in the field, you would qualify for that criteria. Commercial success in the performing arts, so that is typically not applicable to EB1A postdocs. And then other comparable evidence is really where, we would throw in everything under the kitchen sink, as attorney Hadley would say. So that's where we would throw in all of the other accomplishments that you've made in your career as a postdoc, that might not, easily fall into any of the other criteria. So for example, if you've presented at conferences, you've had other leadership roles as part of committees or work groups, then we would throw that all into other comparable evidence to show that you have made a record of achievements in your field. Okay, I see a question in the chat. How many criteria should match? Is there any number limitation? So there's no limitation on the maximum number of criteria you can meet. The more criteria you meet, the better. But the minimum that you have to meet for an EB1A is 3 criteria. So you do have to meet 3 criteria at minimum. Okay, any other questions about the EB1A criteria? Okay, so we'll move on to, I'm sorry, I did get a question as a direct message. Okay, so this question is with regard to criteria point number 8, performance in a significant role for organizations or establishments with a distinguished reputation. And the question I got is, would an Indian company serve this purpose? And the answer is yes. So it doesn't have to be for a company that's based in the US. If you had, if you worked in a critical or leading role at a distinguished organization abroad, that would also qualify you to meet this criteria. It's a good question. Okay, we'll move on to EB1B. So the EB1B is the Outstanding Researcher Green Card, and this one is different from the EB1A and the EB2NIW slightly because it is designed for outstanding professors and researchers who have made significant contributions to their academic or research fields, but you do have to have your employer support this green card. So in order to qualify for the EB1B, you must qualify for at least having 3 years of experience in teaching or research in your field, or you have a tenure track teaching or research position at an institution of higher education. So this is an employer-sponsored green card. And the good thing about the EB1B is that unlike the EB1A, you only have to meet 2 of the following. So most of the criteria, as you can see, is very similar to the EB1A, and this is everything we just covered. But unlike the EB1A, you would only have to meet 2 of these criteria in order to qualify for the EB1B. Okay, I did get another question in the chat. Can any postdoc outside the US apply for these visas? And the answer is yes. So you don't have to be based in the US to apply for these green cards. You can apply from them, anywhere. We have clients all across the world who have applied for these green cards. And it's a slightly different process for the second step that we'll go over. But yes, you do not have to be based in the US to apply for these green cards, and you can begin this process at any time. Okay. Yes, so as I mentioned, this is an employer-sponsored green card. Although no labor certification is required, we must submit a copy of your job offer. And that contract must also very clearly stipulate the title, terms, and conditions of the position offered. And it has to be a research or teaching-based position. I'm getting another question here. So, do non-English language publications count too? Does the applicant need to provide the translation? Yes, so non-English language publications would count as well. And we would have to submit translations of any documentation that's provided in another language, in a foreign language. But yes, it would qualify. That's a good question. Okay. Okay, so we'll move on to the EB2 NIW, which is the Exceptional Ability Green Card with the National Interest Waiver. The EB2 NIW is a lower standard of proof as compared to the EB1A, and this green card is for individuals with exceptional ability in their field that allows you still to bypass the very cumbersome labor certification process, and we have to demonstrate that you are able to benefit the US. So we must prove each of the following. We have to first prove that your proposed endeavor has substantial merit and national importance, which as a postdoc here in the US, you would definitely be able to meet that first prong. We then have to show that you are well positioned to advance your proposed endeavor. And we do this by demonstrating that you meet at least 3 of the EB2 and IW criteria. And finally, we must show that it is beneficial for the US to waive the job offer and labor certification requirements. Okay, so for the EB2 and IW, we also, similar to the EB1A, must show that you meet at least 3 of the following criteria. So firstly, receipt of a degree, diploma, certificate, which all of you would qualify for. We also have to provide letters documenting at least 10 years of full-time experience in your field or occupation. Salary or other remuneration for services that demonstrate your exceptional ability. Recognition for your achievements and significant contributions to your industry by peers, government, professional, or business organization. And this recognition could be in the form of awards as well. A license to practice your profession or certification for your profession, membership in a professional association, and other comparable evidence. Okay, so for this, for the EB2 NIW criteria, like I said, it's a lower standard of proof, which means that it's not scrutinized as heavily as the EB1A. We are showing here that you have risen to a level that's just above your peers in the field and that you have exceptional ability in the field. And here we really have to hone in on your proposed endeavor to show how your work is in the national interest of the US, which again, as a postdoc here in the US, most of you, this should be fairly easy for most of you. So some of the differences in the criteria for the EB1A and the EB2 and IW, though, is that, for example, with the membership in a professional association, if you are a member of any professional association, let's say you join the American Biological Society tomorrow and you pay a fee of $50, that would automatically qualify you to meet this criteria. So it's one of the easiest criteria to meet because, it's a simple paid membership into a professional association would help you meet that criteria. Also, all of the criteria for the EB1A also applies to the EB2 and IW. So again, if you've authored any scholarly articles, if you've judged the work of others, if your work and if you and your work have been featured in major media and trade journals, that would all qualify you to meet the EB2 and IW criteria. And so again, with other comparable evidence, this is where we would add in any other work in your field that you've done, such as conferences that you've attended and presented at, or posters that you've presented, as well as, any other leadership or committee work group work that you have in the field would qualify you for the EB2 and IW green card. Okay, I see a couple of questions here about the J-1 visa and the J-1 waiver. I'm going to hold on to the responses for those questions because Attorney Hadley will be describing the J-1 waiver process and exactly when you would need that waiver just a little bit later on in the presentation. So we'll get to those very soon. Okay, so there's no better time to apply for the EB2 and IW because we received updated guidance for the EB2 and IW, particularly for STEM majors. So I believe in the latter half of 2022, the Biden administration released, an executive order, basically describing how they would like to increase the number of STEM degree holders within the countries to fill skill gaps, drive innovation, and increase the country's scientific and technological leadership. So they came out with a critical and emerging technologies list. So if you Google critical and emerging technologies list, you will see a list of fields like this where your work is bound to align under. So there are several fields as well as subfields under the critical and emerging technologies list. And if your research or your work aligns with any of those fields or subfields, that is a very strong indicator that you would, qualify for an EB1A or EB2 and IW, because these are fields that are basically being, we're seeking individuals with experience and skills in those fields, particularly. Any questions about these fields or about the criteria in general? Okay. So we'll move on to the process for the EB1A and the EB2 and IW. It's a two-step process, of which the first step is the I-140, and the second step is the I-485, which is the adjustment of status. So the I-140 is where we are applying for your employment-based immigrant visa. So this is where a lot of our work goes into, because we very much, work with you to prepare a strong case for how you qualify for either the EB1A or the EB2 and IW green cards through, demonstrating that you meet at least 3 of those criteria and that your work will substantially benefit the United States. Right, so this is a very, I would say, with the main aspect of the green card process, because we are essentially arguing with USCIS and proving your extraordinary or exceptional ability. And we do this by submitting the form I-140. There's a $715 filing fee that must be paid to USCIS for the form I-140. And this form is used to establish that you meet the eligibility criteria for the specific employment-based immigrant visa category, whether it's the EB1A or the EB2 and IW. Something important to note about filing the I-140, which is step 1. So as soon as you file the I-140, you establish your priority date. Priority dates are super important. We'll go over them very shortly as well. But it is super important to file the I-140, which is step 1, so that you establish your priority date and essentially secure your spot in the queue for green cards. The I-140 can be filed with premium processing for an additional $2,805 filing fee that you would pay to USCIS. They would expedite the processing of the I-140 and would provide a response to us within 15 business days. And that response could be either a request for evidence, which is an RFE, where USCIS might ask us to provide additional evidence to prove that you meet certain criteria. Or it could be an approval right away, which is what the general trend is for the EB2 and IWs in particular. Okay, You can file multiple I-140 applications in different categories. So what that means is if you would like to apply for both the EB-1A and the EB-2NIW, you can file I-140s for both of them at the same time, and that is completely fine. So if you do not opt for premium processing, USCIS's processing times are typically around 9 to 12 months, and this could be longer if an RFE is issued. So with the I-140, the process that our firm, takes on as well, and most firms would do this as well, is to start to assemble all of your evidence, and most importantly, your letters of recommendation. So we submit ideally around 6 letters of recommendation with your EB-1A or your EB-2NIW petition. And ideally, 3 of these letters should come from personal sources. So these are individuals that you have directly worked or collaborated with in the field. So this could be, individuals that you've collaborated with for research, your employers, your PIs, your supervisors. So 3 personal sources would be best, and then 3 objective sources. So these are individuals who you've not directly worked or collaborated with, but who are experts in your field, who can describe the significance or the importance of the work in your field. And this could be colleagues in your extended network that you might not have directly worked with, but perhaps a colleague you've met at a conference, or that you might have served on a panel with, but not directly collaborated with, or worked on any projects with. I do see some questions coming in. Okay. I will see some of those questions towards the end. Okay, and so with the I-140, we do have to provide the evidence that you meet those 3 criteria, right? So any of your scholarly articles that you've published, we would submit copies of those articles, copies of, any membership in professional associations. So whether that's a screenshot of the dashboard of your professional association, or certification that displays that you are a member of that professional association, we would submit all of that, advanced degrees, Google Scholar citation profiles, and so on. And so, like, there was a question earlier, for any foreign language documentation, we would have to submit translations before we submit to USCIS. Any questions about the letters of recommendation? So I got a question saying, should the publication be from the US or anywhere? The publications can be from anywhere. But again, if they're in a foreign language, we must submit a translation. Another question we commonly get about the letters of recommendation is whether all of the letters should come from recommenders within the US, and the answer is no, that's not necessary at all. So if you've worked closely with individuals outside of the US, if you've worked on research together, or if they're experts outside of the US who can attest to the significance and importance of your work, that would be even better, really. So you can get a good mix of recommenders for your profile. Okay, so does the time spent working on obtaining a PhD count towards the 10 years of work experience? Yes, generally, yes, that does count towards the 10 years of experience. Okay, please elaborate on the 3 objective sources. Sure, so the 3 objective sources, as I mentioned, would be experts in your field who you have not directly worked on, worked with or collaborated with, but who can talk about the importance of your work. So if you have any colleagues or anyone in your extended network, in your professional network, who can kind of describe, some of your work. So for example, for an EB-2NIW petition, if you're able to get an expert from your field to discuss the national importance of your work, that will qualify as an objective source. And this is maybe perhaps someone who has not directly worked with you or collaborated with you, but who can describe the general national importance of your work and the national interests of your work. Any other questions about the objective sources? Okay. think we can move on. Okay, so the next step in the process, and this is step 2, would be the adjustment of status, which is the I-485. So the I-485, the USCIS filing fees would be $1,440 per applicant, $950 for any applicant under 14 years. So if you have a child under 14 years, they would be paying $950 for the I-485. You do need an approved I-140 and an immediate priority date in order to file the I-485. So we'll go over those priority dates very soon, but you do need your priority date to become current before you can file step 2, which is the I-485. And submitting the I-485 provides 2 main benefits. So you get to also submit 2 forms, which is the I-765 and the I-131. The I-765 is for unrestricted work authorization, and then the I-131 is for travel authorization. So when you file the I-485, typically there's about a 4 to 6 month period where you will be waiting to receive your work and travel authorization. And during that 4 to 6 month period, it is advised that you do not travel outside of the US because that would be considered as abandoning your green card application. And that 4 to 6 month period only starts after you file step 2, which is the I-485. So that does not apply to step 1 at all. So when you file the I-140, which is step 1, you are free to travel in and out of the US as long as you have a valid status, right, to re-enter the US. But when we filed step 2, the I-485, this is when that 4 to 6 month period while you wait for your I-765 and I-131 to get approved, you will have to wait to receive that before you travel in and out of the US. And then the overall processing times for the I-485, we're seeing currently around 9 to 12 months. So some of the evidence that we would submit for the I-485 adjustment of status would be your birth certificate and translations, any marriage certificates and translations, because your spouse would be eligible to apply for the adjustment of status with you. So we would have to submit copies of your marriage certificate and translations if applicable. Evidence of continuous lawful presence, so any copies of your I-20s, DS-2019s, etc., would all be submitted at this stage, as well as passport and visa copies, passport photos for your application, and then finally medical exams. So USCIS requires that you perform medical exams with a civil designated surgeon in your area. And you would submit these medical exams with your I-485 for your final green card application. So do I have to do separate process for my spouse and child? Yes, so with the I-485, you would be, if you do have a spouse and child, we would be filing an I-485 for you, your spouse, and your child. There would be 3 different forms and 3 different packets, essentially, that we would submit to USCIS. That's a good question. Any other questions about the I-140 process and the I-485 process? Okay. Okay, so some of the benefits and potential challenges that you might encounter throughout this process so that you're aware. Of course, the benefits of the employment-based green cards does lead to career advancement and mobility, because as a postdoc, once you do receive the EB-1A and EB-2 and IW green cards, you can secure positions in academia, research institutions, or industry. So a common misconception is that if you do receive one of these green cards, you have to continue working at a research institution or in academia strictly, but that's not the case. You can also work in the industry as well. And then, of course, the EB-1A and EB-2 and IW does not require employer sponsorship, meaning that you can start this process at any time by yourself completely and without, an employer backing you at all. So the green card does give you stable immigration status and that unrestricted work authorization as well. And then it is a pathway to citizenship, because 5 years of permanent residency would qualify you as well to naturalize and become a citizen of the US, but you're not required to become a citizen. So if you'd like to retain the citizenship of your original citizenship, then you are totally free to do so as well. And then the benefits, of course, for your families, that you would get work authorization for your spouse so that they can work in the US as well. And that's as soon as you file the I-485. So there's a good question in the chat. So the waiting period for I-140 and I-45 to be approved are separate and sequential, with at least around 18 months waiting period total. So yes, that is the case. So it is separate and sequential with around 18 months waiting period total. However, for the EB1, for countries other than India, China, I believe you are allowed to apply for both the I-140 and the I-485 at the same time. So you're able to do a concurrent filing for both the I-140 and I-485 at the same time. So it does not have to be sequential in the sense that you can apply for both at the same time, and that's all based on the priority dates. And so actually for the visa bulletin and the priority dates that we're about to get to right now, in the past, about 1.5 to 2 years ago, the priority dates for the EB2 were current as well, meaning that you were allowed to apply for both the I-140 and the I-485 at the same time concurrently, which was obviously a very great benefit of applying for these green cards, because you got that work authorization and travel authorization much quicker and faster. But the visa bulletin has retrogressed significantly. And for that reason, the priority dates have been pushed back, and we are not able to file concurrently in the EB2 category anymore. However, some individuals in the EB1 categories are still eligible to file concurrently. So yes, that is one of the potential challenges listed here, is the visa backlogs. Green card availability is dictated by the visa bulletin, so it's very important to secure your line in that queue as soon as possible by filing your I-140, which is the first step in the process. And of course, we might also get an RFE, which is becoming increasingly common as USCIS continues to scrutinize these kinds of applications, especially with these backlogs. And so an RFE, as I mentioned before, is a request for evidence, where USCIS will assess all of the evidence that we provided in the initial submission, and they will essentially come back to us and let us know that perhaps they've found that you've met one of the criteria, but we need to provide additional evidence to qualify to meet the additional 2 criteria that might be required for the EB1A or the EB2 NIW. So that does, cause a little bit of extended time in the overall processing time. So plan accordingly in terms of your status as well. Okay. I will move on to priority dates and the visa bulletin. Before I get to this section, let me try and answer some of the questions here. So what happens if you file the EB1A concurrently and the I-140 gets denied? Is the I-485 refunded? I will let Attorney Hadley get to that question, actually. That's a very good question. So this is a good moment for me to turn over to you, Hadley, if you'd like to introduce yourself.
Hello, everybody. How are you doing? I'm Hadley Baramovich, and I know one thing that Marisha mentioned about me earlier is that I started my career at the University of California, Riverside. And while that's true, after I was barred, but I started my career in Memphis, Tennessee. I was working with the immigration law firm there, and I went to law school at the University of Memphis. So you guys are in my home. So I'm very happy to meet you. The question that I think that Marisha wanted me to answer is about whether or not the I-485 fees would be refunded if the I-140 is denied. And the answer is no. The reason to file concurrently the I-485 usually is if somebody needs work authorization or advanced parole. That's a permission to travel in and out of the U.S. while the case is pending. Our policy is to file the I-140 only if you have a status that allows you to work and travel, because of that issue that the I-45 is more expensive now. It became more expensive April 1st, 2024. The fee used to be $1,225, and it included work authorization and advanced parole. And then after the fee increase, it is now what, $1,440, Risha?
Yes, it's
Right?
$1,440.
And
And
you must pay,
additional, yeah,
okay, and you must pay for every additional benefit on top of it, because so it does become quite expensive. So if you have an H-1B or J-1 with plenty of time left, I would recommend that you don't file the I-45. Does that answer the question? Yeah, I think that got it. That got it. Yeah. The USCIS is not an institution that does refunds, sadly. We've seen them refund, but on totally different circumstances. Like if they don't require a biometrics fee, a fingerprinting fee, they'll refund that. But I've never seen a refund in my 20 years on an I-45. Okay, does country of origin determine approval of I-140 or strictly based on research and evidence? Wow, that's $1 million question right there. The country of origin should never determine someone's eligibility for this category. That is considered discrimination. Country of origin can never be a reason for making any type of hiring decision or decision based on merits. Country of origin can be considered in the lottery. That is not a discriminatory practice in that setting where the U.S. is giving out green cards based on your national origin. That lottery happens every year around October. And I don't know the countries of origin of the participants in this group, but you might be eligible for the lottery. And I highly encourage you to look into it and see if your country is listed as a country in the lottery, because it's a free process. You should never pay for it. And it's an easy way to get a green card if you're from a country that has low numbers of immigration. But what we do know in practice, that if you are Indian national and you apply for the EB-1A, there's a 90% chance that we're going to get a request for evidence, even if you've met all criteria. It's basically a burden of proof marathon that the USCIS makes us run. They make us run it the whole way and jump every hurdle. So the USCIS would never admit that, though, because that is discriminatory in nature. I'm going to get the next question, Versha. I think you deal with that daily, and I'm going to on translations.
Yeah.
I'll quickly the J-1. I would recommend that you to start the green card, maybe depending on your career, not on how much time is left in your J-1. The J-1 gets tricky when we talk about the 212E, and I'll cover that fully in just a moment.
Okay, Hadley, very quickly, I could talk about the translations. So can use any translator's office that you want, and the translations do need to be notarized. For some of those publications that are in a foreign language, because they're several pages long, we do sometimes just provide translations that we can generate online. But for more official documents like your birth certificates and your advanced degrees, we would want to submit an official translation and certified translation. Okay, so I think we can move on to talk about priority dates and the visa bulletin.
And I'll discuss the J-1 fully in just a moment.
Mm-hmm. Okay, so as I mentioned earlier as well, your priority date is the date when you file the I-140, and this is very good because we don't have to necessarily wait for the approval of your I-140 to secure that priority date. It's determined as soon as you file it. So if you were to file your I-140 tomorrow, your priority date would be August 22nd, 2024. And this is very important because as you familiarize yourself with these visa bulletin tables, you'll find that they are dictated by those dates, and your priority date is very important for dictating when you would be eligible to apply for step 2 of the process, which is the adjustment of status. So yes, these are issued monthly by the Department of State. You'll see the visa bulletins change every month. Sometimes there'll be no change at all, which can be very frustrating. But other times we'll see more significant changes, and that's usually around the month of October, which is very quickly approaching, because that's the start of the new fiscal year. And these visa bulletins are dictated by country of chargeability, so they are allocated based on place of birth. So you would understand more just taking a look at these tables. So hopefully some of you are familiar with this table, but if you're not, the table A for the employment-based green cards would essentially show the priority dates and when you're eligible to apply for, again, step 2, your adjustment of status. So for row, if you see under employment-based, we have the first row. And under first row, this is for EB1s. So EB1As and EB1Bs would qualify under this first row, would fall under that first row. The second row, so employment-based second, would be EB2s. So EB2 and IWs would be paying most attention to that second row there, because that would dictate when you would be eligible to apply for step 2 of the process. So as I mentioned before, EB1As from all chargeability areas, EB1As and EB1Bs from all chargeability areas except those listed here. So except those from China, India, Mexico, well, Mexico and Philippines is current, so China and India would be eligible to concurrently file the I-140 and the I-485 for that first row, right? And then EB2 and IWs, however, has been retrogressed for all countries of chargeability. So regardless of where you're from, you would have to follow the dates listed here in these different columns based on your country and area of chargeability. So what that means, for example, if you apply for the EB2 and IW, and like I mentioned, if you apply tomorrow with your I-140, your priority date would be August 22nd, 2024. As you can see here for the EB2, all chargeability areas except those listed, the priority date is 15 March 2023. So we would have to wait until that date becomes August 22nd, 2024 before we can file your adjustment of status. So there's about a 1.5 year backlog, around a 1.5 year backlog for EB2s. I hope
There's,
yeah.
I wanted to mention there's also the concept of cross chargeability, that if you're married to an individual from a country that's not as severely retrogressed, then you can use that person's country of origin and use their priority dates. Because, like India and China are more severely backlogged than, let's say, England or most other nations of the world. So if anybody here has a spouse who is from another country that is not as severely retrogressed, then the priority date can be applied to that, your spouse's priority date.
Thank you, Happy. And we have a question here that says, can one pay the priority processing fee sometime after the filing of the I-140?
Do you want to answer that, Marissa?
Sure.
Go ahead.
I can answer that. So that's a very good question. And the answer is yes, you can upgrade your I-140 to premium processing by paying that fee and submitting a form to upgrade your I-140 to premium processing at any time after filing the I-140. Currently, if you're filing for the EB2 and you're filing under the EB2 category, we don't see any benefit in applying, for premium processing, because even if you get the approval of the I-140, we do have to wait for this visa bulletin here to become current for your priority date before we can apply for step 2 and get the final adjudication of your green card. Okay. Even if the spouse is not the I-140 applicant. I think that's
yeah, that's the point. So if your spouse maybe is not an academic, but is from, I'm going to just use the United Kingdom as an example, then you can use your spouse's priority date to hasten your case to that date. So, and my hypothetical, if you're an Indian national and your priority date is in 2012, but you're married to a UK national whose priority date is probably 2022, then you can use your spouse's priority date 2022, even if the petition is filed under your merits. Yes. So, when you're married, you're considered a single unit. So you can choose which priority date from the couple. Does that make sense? These things that seem so obvious to us sometimes, we realize, that they're quite complicated when you try to explain them. Perfect. Okay, there's another question.
Yes, so that's, I think, in relation to premium processing kind of again. So after my I-140 is accepted, nothing changes in regards to my immigration status until I-45 is approved.
That is correct. The I-140 is a petition for a visa. It works that way in all realms of immigration, that we normally have a visa petition first, but the application to adjust status is required to actually be admitted to the United States. And that I-485 application to admit you to the United States is the one that confers an underlying or secondary, or in some cases, the status. One thing that Varish and I see every year is around July, because that's when the academic calendars usually begin at universities, and people are suddenly in a lab without funding, and they have no status. So we try to find a way to give that person a new status through the green card filing. And we do that by filing the I-485 and the I-140. And we haven't been able to do that so much anymore because of the retrogression and these priority dates not allowing us to do that. But there are some cases, like if, example, we'll go back to somebody from the United Kingdom, that person would be able to file concurrently, right, Versha?
Mm-hmm.
That category is current, right? So, yeah, so if somebody from the UK were on an H-1B or a J-1 and their funding ended and the university gave them notice, we're not going to renew your contract, we might have to do an emergency green card filing, I-140 and I-485 to give that person continued lawful presence in the US and work authorization. Although the work authorization would still take about 3 to 4 months to obtain. But that's something common in the immigration world to do.
Hey, Virisha, this is Sandesh. Before you move on, I have a quick comment. Can you comment on the importance of securing an early priority date by filing an NIW, as it does not have a stringent criteria, and then using that date for your EB1A application, especially for Indian citizens, because as you showed, it's backlogged 10 years ago, 12 years ago. That's crazy. So,
right.
That's a great question, Sandesh. And we see this all the time, and a lot of our clients employ this strategy as well. Hadley, do you want to talk about it more?
Well, if somebody has an EB2 NIW filed, and their priority date is like, we were using this the other day, Risha, they had a priority date that is current. I'm sorry.
Yes.
This is really hard to explain. We can capture the priority date from the petition that was prior filed for the EB1A. If somebody files the EB1A. What was the situation we had yesterday, Marisha, where we figured this out? I think using a hypothetical is easier.
Right. So very recently we had a consultation very similar to the situation Sandesh just described, where we had an Indian national who had an approved EB2 with a priority date in 2017. And now they're looking to file an EB1A so that they can, get ahead of that, of the visa bulletin, because as Sandesh mentioned as well, for India, it's retrogressed all the way to 15 of July 2012 for the EB2, and we very, very rarely see any significant movement in this date for that specific country. So for the EB2, if you have a priority date of 2017, that's good. I think it's generally good to secure that priority date as soon as possible. And then maybe, let's say, in about 4 to 5 years, once you've built your profile, to the standard of an EB1A and you qualify for some of that EB1A criteria, what you can do is then apply for the EB1A. And once we get the approval for your EB1A, as Hadley was mentioning, we can port the priority date of your approved EB2 to your EB1A so that we can then file your adjustment of status for the EB1A. So in that example of the consultation that we just did, as Hadley mentioned, once we get the approval for this individual's EB1A, they will be able to port their priority date of 2017 to their EB1A. And as you can see for the EB1 India category here in the visa bulletin, 2017 would allow them, a priority date of 2017 would allow them to file step 2, an adjustment of status for their case.
Yes, and the reason why this might be confusing or more complicated is we didn't have to do this before a year and a half ago. Marisha mentioned this at the beginning of the call, that the retrogressions in the visa availability have been really devastating. The EB1A category, that was current across the board for every country for decades. I mean, we didn't have to port EB2 and IW priority dates to an EB1A because anybody could file concurrently an EB1A and an adjustment of status because everyone was current on the visa bulletin. And then it's been a year and a half about, right?
Yes.
There was a retrogression even in the EB1A category. And, that's insane because the US is trying to attract the best and the brightest. But with this crazy visa bulletin, it makes it hard for us to do so. So we do have those kind of methods. And yeah, if you file an EB2 and IW, it could be your backup plan in the future.
We have another question in the chat, Hadley. What if while you're waiting for your I-140 or I-485 approval, what if you marry a US citizen? Can you get the green card sooner?
Yes, unfortunately. There's no wait if you marry a US citizen. The family preferences are that the marriage to a US citizen is an immediate relative, so there's no wait. Okay, so no wait for marriage to a US citizen. The green card takes about 8 months. If you were to file an I-140, like let's say as an EB2 or an EB1 and you have a backlog issue, and then you meet the love of your life and the life as a US citizen, and you want to submit an I-130 through the love of your life, you can do that. You can have an I-140 and an I-130 processing at the same time. But with an I-130, it's going to move so quickly that the I-140 will become irrelevant soon. The adjustment of status filing that you make with any of these petitions can be connected to any one of the visa petitions. This is a trick that we've done successfully maybe twice in my career. But if you file an I-140 with an adjustment of status, and then you file another I-140, which the USCIS allows you to do, you can file multiple I-140s under every category if you wish. If you file an adjustment with one of them and then realize, oh, that one is going to be denied or that one is not going to work, you can contact the USCIS and they'll move your I-45 to another I-140. It's complicated, but it can be done.
Okay, and then can we move to H-1B after applying or approval of I-140 during J-1?
Yes, you may, and we recommend that because the H-1B is a dual intent visa. It was actually created to allow a bridge or a way for people to move between non-immigrant visas that might be temporary intent, like the J-1. Temporary intent, of course, means that you have a temporary intent to remain in the U.S., that somewhere down the line you intend to return to your home country. Permanent intent means that you plan at some point to get a green card. Now, having been in an international services center at an R1 university, I know that very often the advisors will say, oh, you cannot go into a green card from a J1 or an F1. That is categorically untrue. You may apply for a green card in the US or outside of the US, no matter what your status is. But it does become trickier if you're in a J1 or an F1 to travel or to make changes to your program once you filed a green card petition like an I-140. And that's why we recommend that you always work with an immigration attorney. I know a lot of people have been self-filing lately, but you know, the approval itself is only 25% of a green card case. There's a lot of procedural loopholes and issues that can come up if you don't know the law and how it works. Okay, there was another question.
Yes, so there's questions about the J-1, so I'll move forward to the J-1 slides.
Okay.
Okay, the J-1 waiver process.
Okay, I cannot see the slide. Let me get, oh, there we go. All right, so the J-1 holders are typically subject to a 2-year home country physical presence requirement called the 212. The J-1 waiver will waive that most of the time. I'm gonna say 90% of the time. Because we are talking to a group of potential medical providers, the 212E waiver may not work. If you are at the University of Tennessee as a medical doctor and you have a J-1 program as a medical doctor, you'll possibly need a Conrad waiver. And the Conrad waiver is a specialized waiver that involves going to work in an underserved area. The waiver that we're talking about here is an academic-based EB2 NIW or EB1A self-petition green card waiver, and it's not based on medical practices, based on scholarly achievements. So I wanted to make that distinction from right away. So the reasons why people are subjected to this waiver is because of receiving money from a government, and you can receive money from your home country or from the United States and be subjected to the 212E. The second reason that people are given the 212E is because of their country of origin. I believe India, for example, has asked in a convention that's held every probably 5 to 8 years. India's requested that virtually all of their scientists that have education in the US and join the J-1 program are required to return to India for 2 years to disseminate their knowledge. Because India has requested this of every single field of study, India is also very gracious about waiving that requirement. So the process is the same for any country, but what we do is ask the government of the country to provide a no obligation to return letter, which is uploaded into a J-1 waiver division of the State Department. That process takes maybe 3 to 6 months. You know, the processing time varies all the time. So we don't recommend that people start that process until they're very close to filing a green card or an H-1B, because any change in the J-1 program will make an approved waiver null and void. So if you're in the first year of a J-1 and you start the J-1 waiver because you have a 212E and you plan on getting an H-1B or a green card, but you're in your first year, I wouldn't recommend that you do the waiver yet. If we know that you're going to get you an H-1B or a green card maybe in your third year, and I mean at the adjustment stage, then we would recommend that you start that waiver about 6 months before the process is anticipated to begin. That way, we won't have to file the J-1 waiver request a second time. It's not an overly burdensome request. There's a fee. I believe the fee is roughly $200. Then you reach out to the consulate of your country and find out what their post process is. I mean, when I say post, I mean their local mission post, what their rules are for requesting the letter. And then you follow whatever their rules are. The consulate that represents you will send the letter directly to the State Department. They won't send the letter to you to send to the State Department. They send it directly to the State Department, but you provide the consulate with barcodes that identify the letter to the account that you've created in the J-1 waiver division. But in general, once your country has issued the no obligation to return letter, it's done. I mean, the State Department has no interest in denying those types of no obligation return letters. If the country says we don't need you back, then they say, okay, fine. Except if you have a 212E on a Fulbright. This is was one of my grievances to the Fulbright program when I worked at the University of California, is that nobody who receives a Fulbright is told that they're going to have to return to their home country, that they're not going to have this direct path to a green card. We cannot waive 212Es for Fulbrights unless there is an interested federal agency, which would be like the Department of Agriculture, Department of Health and Human Sciences. Some federal department would have to write a request for that waiver, and that's very rare. It's almost a unicorn for that to happen. I mean, in my career, I've seen it happen once, and we've filed more than 1,000 cases in my office. So one of the other sensitivities about filing the J-1 waiver is if you plan to travel in the near future, that can be considered a change of the program, because when you exit the country on any non-immigrant status, you literally stop your status when you get on a plane or walk over the border. Your status is ended. And then you regain your status when you come back and present your visa. That can be considered a change in the program. And that could trigger the need for a new waiver. So for our clients, we work very carefully to plan out when to file the J-1 waiver so that there won't have to be a repeat filing. Do we have any questions, Marisha? I'm not seeing.
We do. So the first question is, any recommendation on the time to apply for I-140 during J-1?
I'm going to say probably if you're confident that you're going to get the full 5 years in your field of study, then I would start around 2 years. You know, most J-1 programs that are in higher education institutions are in postgraduate roles. So to be a postgraduate in institutions like the University of Tennessee speak to the merits alone. We know that you probably do have a strong enough case to move forward with the green card. So we would probably want to start working on your self-petition in your second year. So yes, that would be my recommendation. Especially with the visa bulletin retrogress like it is. You need more time. Okay.
The next question is, how long can you still work on the J-1 after getting final 212E waiver from USCIS?
You can continue to work in that program as long as you want, up to the 5 full years, even with the waiver. The problem comes if you change the program. So many institutions will only issue a program 1 year at a time. So if you're in one of the, if UT is that type of a institution and you get the waiver on your second program, you still have 3 more programs, right? That they're going to issue. So they're going to renew your DS 2019 every year. So we have to be careful about when to apply for the 212E, but you can continue to work under the J program, even with the renewals and with an I-140 filed, as long as the J-1 program is not terminated. So if you have, if you're in the second year of your J-1 program and you've applied for the I-140, you can still work in that J-1 program for 5 years. We just have to be careful about the 212E waiver, when to do that.
Okay, we also have a question that says, my visa sticker says bearer is not subject to section 212E. Does it mean that I have the waiver already?
Yep, means that you were not subjected. But we always have to look at your visa, and that is, you know, issued by the post where you applied for the J-1 visa. The consulate decided you were not subject. But you also have to look at your DS 2019 because your program officer who created your DS 2019 might have put something into the SEVP system that says you are subject. So there are 2 places that we have to look to determine if you're been subjected to the 212E. So just to repeat that, you must look at your visa and you must look at your DS 2019. It's on the left-hand side in a box, the bottom of the DS 2019. And it'll even tell you why you were subjected. If you received financing, or if you're on the skills list that was decided in the convention. And then they even have another one, like you received funding that was earmarked, meaning, you know, maybe planned to be a government funding. I don't think anybody knows exactly how to use that category. But usually people are subjected to the 212E because they've received government funding or because their country has designated your field on a convention that states they want you to come back.
Okay, that's all the questions I see in the chat for now.
Okay.
And so we'd like to open it up to any other questions that you might have. Attorney Hadley. I did get a question earlier, Hadley, a direct message that said, is there a minimum number of citations that you would require to be eligible to file the I-140?
No, I'm like a big believer that citations don't matter. Citations are indicative of the influence in the field, but they're not the only indicator. And we have some attorneys that will look for citations. If they don't see it, they're not going to take it. Well, that's because they only want easy cases. And my firm takes on the cases that we believe in and that we believe we can win. If we don't believe we can win, we don't file the case. So we have right now a 95% approval rate. And that's because we do work through our analysis with our clients to determine how we're going to advocate and meet the criteria or meet the standards. And if we believe we can do it, we take it. And we've established a very good reputation with the USCIS. As I mentioned earlier, we've filed more than 1,000 cases with a 95% approval rate. I think I saw a question about fees. We can give you ranges. You know, the fees can be varied depending on the type of case. Barisha, will you go over that really quickly?
Yes. So the ranges of our fees for the EB1A to the EB2NIW would be anywhere from $5,000 to $7,000 for the I-140. And then I saw a question as well, could you provide reference letters as well? So as I mentioned during the presentation, we collaboratively draft these 6 recommendation letters with you. So we have our own, templates. We have a library of samples for letters of every field possible now through all of our expertise in preparing these cases. So we collaboratively draft these 6 recommendation letters, and by that I mean we provide the templates, the outlines, right? But we require some input from you, and this is just the technical input of your work because you know your work better than anyone else, and you're the expert in your own field and work, and we rely on you for that technical input into the letters. But we assist with drafting these letters of recommendation, and they're included in the fees. So there's no additional fees for the reference letters. Those are good questions. Yeah.
Yeah. And we've built up a library of thousands of recommendation letters. I don't think there's a field we haven't worked in. Well, there are, I'm sure. You know, science is evolving and becoming, everything's in hybrid now. So we normally have something that's pretty close that we can give to you to show you what our end result should look like. We've also heard, through the social media grapevines that people are being approved with fewer recommendation letters, but we have a tried and true method that we prefer to stick with. And this is your life and your money and your hopes and your dreams. So we want to fight the case the way that we know wins.
There is another question.
Yes. Barisha, can you read that question?
Yes. So does the date of filing and final action date both have to be after your priority date? Like if my priority date is 3/20/2023, can I proceed with I-485?
So basically, yes, those 2 dates must be after your priority. One date determines when we can file the adjustment. And is that still true, Barisha? Because they changed that. Sometimes they'll take the date of filing away from I-140s.
Yes, it's still true. And yes, like you said, Hadley, the USCIS tends to change this with every visa bulletin that they issue, right? So, but for the main distinction between Table A and Table B is that Table B indicates the date when we are allowed to submit Step 2, so that I-485 adjustment of status, we're allowed to submit it to USCIS. Table A determines the date, the final action date, so the final adjudication of your green card, essentially. So Table A dictates when we're allowed to submit. Table A dictates when they are allowed to approve that final green card. So if there's a gap between the dates, what this could mean as well is, for example, if Table B has a date that's a little bit, let's say later, so you meet the date on Table B, but not on Table A just yet, then we're allowed to submit an adjustment of status application for you. And this could result in, that travel authorization and the work authorization as they start processing your I-485 adjustment of status, but they won't approve the final green card until the priority date becomes current on Table A, which is the final action date. Okay.
I remember when they split the table like that 7 or 8 years ago, and attorneys were like, what? They were just like coming unglued over it.
Mhm.
I see there are other questions.
Yes, I think the questions about the visa bulletin were answered. So another question, how many reviews do we need to do for journals to be eligible for the EB1A apart from other categories?
Peer review usually helps, but is not a criteria in itself. If we're talking about peer review is considered part of the postdoc journey and does not distinguish somebody unless it's voluminous. We had people that had exponential numbers of peer reviews that we believe did work in their favor. We're talking about somewhere above 50. But under 50, and that's an arbitrary number that I'm using, and it really depends on what your role was as a reviewer. I mean, you know, like if you're the editor of the magazine, that's completely different. You're meeting another category. But if you're peer reviewing articles by your colleagues, that's considered normal until you get to, you know, voluminous numbers of reviews. And we would just assess that with you individually. And it's all about advocacy, like how we're going to explain it and tell the story and show that this was exceptional. And generally, what we say is that you've risen above your peers, because your peers typically do 10 to 20 reviews, but I did 50. And, you know, that shows, you know, how prolific I am and how people want me to review their journals because of my expertise. So it's about how we, you know, spin the tale and explain.
Okay, I guess we are done with the questions and answers. And if any questions is there from the colleagues and from the students, Virisha and attorney is always there for any questions to be answered. And thank you so much for the valuable insight on how to get the green card for postdocs and for the graduate students. Now, as we have come to an end, I would like to give a vote of thanks. I would like to express our deep appreciation to everyone who had made this event possible. First and the foremost, a heartfelt thank to Attorney Hadley Bejramovic and Virisha Perere for your insight, expertise, have been an instrumental in guiding us through the complexity of the green card application process. We are incredibly grateful for your time and effort in sharing this critical information with our community. I also want to extend our sincere thanks to UTHSC leadership for their unwavering support. Special thanks to Dr. Monica Jablonski for her continued guidance and Dr. Donald Thompson for his dedication to the professional growth of postdocs and graduate students. We are equally grateful to Peggy Mohane and the UTHSC Postdoc Office for their essential role in organizing this event. Lastly, thank you all, the participants, for your active engagement. Your presence and enthusiasm make the event like this true impactful. Thank you, everyone. Thank you, Virisha, and thank you, Attorney Bejromic. Thank you.
It was a pleasure.
Thank you. I think we will end now. Do you have anything to say, Virisha?
Yes, thank you so much, Abdul, for helping us facilitate this webinar. And thank you to the UTHSC leadership and the Postdoc Association. We appreciate the opportunity to present today. Thanks to all of our participants for asking such insightful questions and for having a great discussion with us. So please feel free to email your CV to me, varisha@ilab.com. To receive a complimentary evaluation and then a complimentary consultation with Attorney Hadley as well. And if you would like to receive the recording or the presentation, a copy of the presentation, feel free to email me as well, and I'll go ahead and send it over to you. Thank you,
And
everyone.
we will be bothering you if you have any questions in future.
Absolutely.
Both of you,
Absolutely.
even attorney. Okay,
Absolutely.
thank you.
Of
Thank
course.
you. All right,
Thank you.
bye-bye.
Great.
Yeah.
Bye-bye.
Bye.